Thank you very much, Mr. Chairman, members of the committee. My name is Kevin Ward, and I represent a number of folks in my practice. I'm a private attorney with Schulten, Ward & Turner. I've had the pleasure of representing a number of developers. I represent some community banks, and I also represent some of the members in the secondary Lending Institute. I was joking with Mr. Thompson that he and I have recently tried a case with me as his counsel, and I see this from many different perspectives, but I think that I can answer some questions that could not. Is that any better? All right, thank you. Many of the points that I have to make have already been covered very well and eloquently by the community bankers from which some of my clients purchase notes. But I did want to cover, in particular, a sort of balancing between the benefit and the negatives of this SB 448 and the modifications that have been presented today. This bill will basically, it will bail out a few people who have multi-million-dollar loans with typically most of the people that are proposing this change, typically with ventures or with banks, whole bank purchasers who have, where their loans have gotten into the hands of either the secondary market or the whole bank purchasers through the closure of banks and the FDIC taking them over as receivership. I think it's very critical to look at the stages that have occurred to get us to this point. First, at some point, these guarantors went into a bank and said, I promise to pay. I promise to pay 100% of the borrower's debt. That guarantee, as you've heard from a number of the bankers, is a critical element of community banks lending. That promise to pay is also an assignable promise, and that is a critical element of the contract that they entered into willfully and with the help very frequently of counsel at the outset of their relationship with the bank. It is not only assignable, it's transferable, and knowingly at the time that they enter their guarantees, they willingly say that they will pay 100% to successor interests. So in other words, they have at the outset of their guarantees contracted to pay successors in interest. That critical element makes, in my mind, leaves no doubt that the bill, as it's proposed, is going to be unconstitutional. And the Georgia Constitution not only looks at retroactivity when you're modifying a note, it's also going to look at how you're affecting contracts that are in existence at the time. There's been a lot of discussion, as is appropriate because of the environment that we're in, with the fact that many failed banks were taken over in receivership by the FDIC. You heard from the banking commissioner that there was something like $80 billion worth of non-accrual assets. A lot of us call it distressed debt, but it's bad loans. You heard that $30 billion of those have occurred quite recently. $14 billion of them are in Georgia. And the majority of those non-accrual assets will, in all likelihood, be handled by one of two folks. It'll either be whole bank purchasers or it'll be the secondary market to whom these community bankers have said it's so essential to be able to sell their loans. Their ability to sell their loans to the secondary market is often the very last thing that prevents them from going into receivership. And if you take that away, it will undoubtedly accelerate the loss of community banks in the industry. I think what's very important in looking at, there are emotional issues, and first of all, I'd like to say that I think that these hearings are being handled very well, very respectfully to all sides, and I very much appreciate that. When these loans were taken out from the original banks, however, you have to look at the equities. There were significant amounts of money that were taken out by the guarantors, who are frequently the same people that are the principals of the debtors. So in many examples, and I can give particular examples in great number, but in many examples, millions of dollars are taken out by the developers who have come in and promised the banks, look, I know how to do this. I will take the risk. I will pay your interest, but I'll take all the risk. This is a good project. And in return for that, when they take out the loan, they take out millions of dollars. And there are many examples, and that's the norm. That's the incentive for developers to come in and do these deals. They take high risk. They get high returns. That money then goes into the pockets of the developers, and it is now very frequently in the hands of trusts, which, as time goes by, become less and less available to the community banks or, in fairness, to the holders of secondary notes. That's because the Uniform Fraudulent Transfer Act has a 4-year statute of limitations. If someone comes in and convinces the legislature to pass a bill that will undoubtedly be challenged and very likely overturned on constitutional grounds, they have bought 2 years of time. During those 2 years of time, the UFTA statute of limitations is running. Many of these banks failed in 2008. So the very practical motivation behind advancing this bill from a private enterprise, from a borrower or a guarantee's point of view, is if I can buy more time and my money has been moved to a trust or my money has been transferred to somebody else, nobody will ever get it. I have personally sat down in a number of meetings where folks have just looked me in the eye and said, we have the money. We're just not going to pay it. And the reason that they're not going to pay it is because it has been put in trust. This bill, I believe, will be found unconstitutional. I know that there are a number of reasons that will occur. I think it'll primarily violate the Georgia Constitution, but it will also face U.S. constitutional challenge. And so if that's the case, why would anybody want it? They would want it because it buys an inordinate amount of time. I do respect that there is a desire to deal with a very difficult situation with more banks that are going to fail. And I even have had discussions with some of the members about the fact that there is what has been called a loophole in the confirmation process, but which is actually not only statutorily correct, but is within the language of most guarantees. Most of the guarantees contain within them a negotiated provision that says the bank may proceed against the guarantor instead of against the collateral. That is a negotiated term which essentially you will change.